Hello everyone. So how was the internship? Everybody enjoyed? Okay. That's in good spirit. Advocate Ashish Chavan, Advocate Lokhande, Advocate Prakash Salsingikar, Mrs. Salsingikar, Prathamesh Gaikwad. बरोबर. All volunteers, lawyers, Mr. Chomal, advocate, and all the interns who had participated in this program organized by Se Humdard Tak. The name itself indicates the object of formulating such an organization to help the people who really need justice. I congratulate this organization for providing and imparting legal aid to several persons who really required it. As it is already said, about more than 500 people were provided justice. Many of them were languishing in jail and they were set at liberty. In my introduction, Mr. Gaikwad had referred to the committee being appointed once by the High Court when I was a lawyer. One public interest litigation was pending before the High Court, and the issue of the prisoners, under trial prisoners or convicts were languishing in jail, the non-availability of the facilities to them, non-availability of legal aid to them was the issue. And at that time, the committee was formed consisting of senior lawyers. I was not a senior, I was a junior lawyer at that time. I was included in that committee, and the committee was supposed to visit several jails in Maharashtra. And pursuant to that order of the division bench of this court, High Court, we have visited several jails, including Mumbai Central Prison, this Eroda Central Prison, Nasik Road Central Prison, and various other jails. This was about 15 years ago, about 20 years ago. And what we could find, I had interviewed several prisoners who were in the jail, that several of them were not even aware what is their legal right to challenge that incarceration in custody. Several of them were convicted and they were languishing in jail undergoing the sentence imposed by the trial courts. Several of them could not afford to engage lawyers to defend them. The problem with the prisoners is, on account of lack of the education and financial stability, many of them keep and continue to be in custody. Long incarceration in custody is one of the factors which matters, which clearly violates Article 21 of the Constitution of India. So Article 21 clearly says that no person can be deprived of his life and liberty unless without the process of law. Being in custody without trial is also affecting or violates the fundamental right of the prisoner who are languishing in custody for indefinite period. It was also noticed at the point of time when we have visited a jail that several of the prisoners who were convicted had undergone substantial sentence, and they continued to be in custody. They were not aware that they were entitled for remission, they were entitled for parole, furlough, and various other facilities which are provided as per the Maharashtra prison rules. So they were required to update, guide, and advise that they have certain legal rights which they can perform, they can exercise by going to the court of law. Article 39A of the Constitution, which was introduced after 42nd Amendment to the Constitution, is with this purpose, is to provide legal aid to the people who require it. It's a responsibility of the state to provide legal aid. But organizations like Se Humdard Tak have taken this responsibility and are visiting jails, and now we have seen the results of the hard efforts put up by this organization to provide the legal aid to the various people. The volunteers of this organization needs compliments for doing this work effectively. And I congratulate all those interns who had participated in this program of how many days?
1 month.
Almost 1 month. To be in jail, I hope you have visited jail also, to be in jail or visit police station or visit courts and try to understand as to what is the fate, what is the problem faced, and the practical knowledge which you have got during the course of this program. Legal profession is the most looked out of the profession nowadays. I recollect when I studied law, there were hardly any people who used to join this legal profession. Most of the students who used to join were only for the purpose of getting promotions, because most of them were employed in some concern. But now we see, particularly after the 5 years course is being introduced, that all those who are seriously intent to pursue this profession are joining the courts of law. There's a lot of competition. And this is where it is required that you should stand out from amongst several other persons by becoming a very effective and the successful lawyer. This internship is definitely going to help you to understand certain practical aspect which is beyond the textbook. This pamphlet of this today's program, as a student of law, we study law. We try to understand theory. But when we pass out law, the real test is to how to practice in the court of law. For that reason, you should have a practical knowledge. And such type of internship is going to help you. When I was a judge, several young students who were studying law used to join me, were interested in joining for internship. And I could find that, of course, some of them, with the exception of few, most of them were really interested in understanding the various concepts of law. But that too also, being an intern with a judge, you get the knowledge of what is happening in the court. But the internship which you have undergone, you got a first thorough knowledge as to what is happening, as to how the first information report is being written, how the people are languishing in jail, what are their rights, what do they do, how they are kept in prison, how they should inform or enlighten about their rights. The lawyer is an important citizen or important part of the country. The lawyer plays a very vital role. The lawyers have fought for the freedom of these countries. The lawyer is an important personality. Lawyers are working for the people. Article 39A is actually implemented with the help of the lawyers. It's because of the assistance of the lawyers, the people who really need justice, they are being provided the legal aid. So the true purpose of introducing 39A is being implemented by the lawyers. Many lawyers who used to appear before me in the court of law, even in many such cases, I could find like Se Humdard Tak, there were various other organizations also probably who were helping the people who really needs legal aid and legal advice. So many of them appear pro bono in various public interest litigations, various important matters where the rights of the peoples are being affected. If you see the various judgments which are delivered by the High Court as well as by the Supreme Court in public interest litigation, they were all pro bono matters. It's all because of the assistance of the lawyers. A good judgment is delivered by a judge. It's only because of the assistance, good assistance of a lawyer. If you have effectively argued the matter before the court of law, the judgment which is delivered by the judge, it's mainly it's because of the assistance rendered by the lawyer to the court. It's how you have argued the matter, what judgments you have cited. Read all those old celebrated judgments like Keshwananda Bharati's case, like ADM Jabalpur versus Shivkant Shukla's case, A.K. Gopalan's case, Maneka Gandhi's case, various other judgments, where real interpretation of the provisions of the constitutional law were being concerned. And they were all argued by the eminent lawyers. So it's a contribution, what I mean to say, it's a contribution of the lawyer which matters when a judge delivers a good judgment. So good judgment is the hard work and a contribution of a lawyer. Hard work is an investment for a lawyer. Since most of you are the interns and many of you are junior lawyers, there is no substitute for hard work. That perseverance is required, that passion is required if you want to be a successful lawyer. You have to start working on it as to how you are going to be a successful lawyer. It's not only that the person who stands first in the class will be an effective or an eminent lawyer. There are many other aspects which would be helpful for a lawyer, which assist the lawyer to become a successful lawyer. It's not only an academic which helps a person to become a successful lawyer, although it does matter. Other than that, there are various other aspects which you must inculcate among yourself when you are going to practice law. First of all, you have to be a voracious reader. You should have a command over a language and command over the legal aspects. That command you can have only when you are a voracious lawyer. Reading doesn't mean only IPC, CRPC or Evidence Act. Reading would mean anything under the sun. You can read novels, you can read journals, you can read newspaper, you can read magazines, articles, anything under the sun. A lawyer is a master of all. I won't say jack of none. They are really master of all. It's because the lawyer is supposed to have the knowledge of all the topics. That's why it's not only this major IPC or the major criminal acts which are supposed to read if you want to become a criminal lawyer. You should read everything. Political science, sociology, medical jurisprudence, criminal jurisprudence, psychology, political science. The reading and the knowledge of all this subject will give you confidence. And reading will develop your language. You should have a strong vocabulary if you want to be a successful lawyer. You are confident to argue the matters in the court when you have a command over the language. And secondly, you are confident when you argue the matter if you know your matter. Thirdly, if you know the law. Knowledge of law, command your language will boost confidence in you when you argue the matter before the court of law. If you don't read your brief, you are incompetent. It doesn't give you confidence. You can't bring your point home. You can't convince the court. You can't pursue the point which you are arguing before the court of law. So knowledge of law and voracious reading are the two factors which everyone should keep in mind. Without reading, there is nothing in this profession. वाचाल तर वाचाल. वाचन फार गरजेचं आहे. That's why lawyers keep on sitting late in the nights, burn midnight oil lamps, and that is the investment which helps them to become a successful lawyer. Lawyer is supposed to know the different judgments. You should keep update yourself. Judgments keep on changing. Judgments are overruled. New judgments keep on coming. Amendments keep on coming. Some provisions are deleted from the law. Some new provisions are introduced in the law. Who is supposed to know this? Lawyer is supposed to know. Even most of the judges doesn't know it, but the lawyers who are the person who bring it to the notice of the court. And it is your responsibility, as it is rightly said by Advocate Prakash D and Mr. Ashish Sawan, that it is the responsibility of the lawyers to help the citizens of the country who really need your help. We have become a lawyer after completing law. Doesn't mean you're only supposed to work for yourself or only for the purpose of earning for yourself. Whatever you have learned, that knowledge should be imparted to others. Although it is said that ignorance of juris is non-excuse, ignorance of law is no excuse, but practically, how many people, hardly any people, even educated people, they don't know the law. So who knows the law and who is supposed to know the law? It's a lawyer who is supposed to know the law. So who will guide the citizens? Who will advise them? It's a lawyer who is going to advise them. A client would come to you with a piece of paper. That one piece of paper can be converted into a writ petition of 50 pages. How? If you have mastered the law, if you know the basic concepts of law, it can be done. When the litigant would come to you, you should know what is the remedy available in law. That's the reason he has come to you. Why we are called professionals? Professional is supposed to be well versed with the provisions of law. Legal profession is supposed to know, it's supposed to be well versed with the provisions. Not that every small integrity you are supposed to know, but at least basic things you are supposed to know. That's the reason the client comes to you. So when a client comes to you, you should know what is the remedy available. It's a civil remedy or a criminal remedy, or it's a representation to be done. What is to be done? For this, the first and foremost thing is, should understand the basic concept, basic principles of law. You may be a civil lawyer or you may be a criminal lawyer. But basic concepts of law, you should understand. Master CRPC, IPC, Evidence Act if you want to become a criminal lawyer. Now the new laws are coming from 1st of July. There are some changes are there, but not much. It's not that completely the earlier laws are being completely changed, but there are few changes. You'll have got to learn. But for all the old matters, you have to go. We'll have to follow those provisions which are already there in force before this new act comes to force. What I mean to say is that if you know the law better, you will be better in a position to advise your client what to do. And if you know the law, you will be better in a better position to argue the matter before the court of law. I am sure that in one of the topic, the etiquettes was one of the topic, correct, of a lawyer. Cross-examination was one of the topic of a lawyer. One, the superintendent of jail also spoke about probably the what is happening in the jail, that those updates must have been given to you. How you present yourself in the court of law is also matters. How you are dressed up, what is your haircut, what side of language you are using in the court of law, because nowadays we say that the WhatsApp language is also being used in the court of law. That yeah, nope, yup, and all this. That should not be done. When you enter the court of law, it is expected that you should maintain the decorum of the court. You should follow the etiquettes of the court. Present yourself. The judge should have confidence in you that you are speaking, you are arguing, you have worked hard. You are presenting your case properly. And you are not dishonest. But that doesn't mean that you are going to tell lies to the court or mislead the court. That is not permissible. And judges come to know, don't be under the impression that judges doesn't know as to what you have done. Judges come to know about it, that you have misled the court or you have told a blatant false statement in the court. And the result of that is when you again appear in other matter, the judge doesn't have faith in you. All this aspect I am telling you because I was on the other side. Now I have come on your side. In many of the order matters, the judge has the discretion to pass order in this way or that way. And many times, 90% times, the judges rely upon the statement of a lawyer. Suppose the petition or the matter contains about 2000 pages. The judge can't read every page. So most of the time, the judges rely upon what is argued by the lawyer. What facts are disclosed by the lawyer. And it's because of their assistance, the matters are being decided within a short span of time. But suppose if it is found subsequently that you have made a false, blatant false statement which is contrary to the record and deliberate false statement, then court also realizes that this lawyer is in habit of misleading the court. So develop your identity before the courts. And a good lawyer, one who argues, one who works hard, judge also carries a good impression about all those lawyers. So all those interns, hard work is the first and foremost important thing. And the second, the most important thing according to me is that you have to be humble. Being humble doesn't cost anything, but you get gains of being humble. Even if you become some successful lawyer on lakhs of rupees, it doesn't mean that that air should go in your head. Be humble, be grounded, be simple. And when you appear before the court of law, present your case effectively. It also depends as to how you argue your matters before the court of law. How you present your case before the court of law. How submissive you are. It's not necessary that you should be aggressive. Sometimes, maybe, when you argue a particular point and you really feel that some injustice is being caused to your client, you become a little aggressive. But you should be able to strike a balance between being submissive and an aggression. Otherwise, there is nothing like you are not supposed to, be aggressive, antagonize the court, irritate the court. No browbeating the court. So that art of persuading the court of law, maybe any court, a magistrate court, sessions court, city civil court, high court or any other court. Art of persuasion, you have to learn that art of persuasion. Court craft, it is called as court craft. That's the reason I said, it's not necessary the first class, first student only become a successful lawyer. An average person that passed out LLB can also be a number one lawyer. How you develop that court craft. So developing advocacy is the thing which should be in the mind of the lawyers who are practicing in the court of law. So she has thought of joining law, it appears. So the law has attracted so many people. Just see this. When I was a student of law, there were only 3 colleges in Bombay side, South Bombay side. One is Government Law College, KCA Law College and Siddharth Law College. And there was nothing like first class, second, only you have to pass in your graduation, admission was very easy. Now it has become very tough. There is CET also, no? There is CET, there is CLAT, so many things are there. And I think most of the students who used to actually initially used to go for engineering, they are now turning towards the legal profession. Many of my colleagues were engineers initially and they have joined the legal profession. One of my friends is an MBBS doctor who subsequently gave up MBBS practice and joined the legal profession. Why? Legal profession is a profession where it really requires skill to survive. It's a challenging profession. But what is noticed is that many students who actually pass out from the National University, they don't intend to join the litigation. But whenever you get an opportunity to be in litigation, be a practical lawyer, be a lawyer who is arguing the matters in the court of law. There is no other best thing than being a lawyer in the court of law. You may get a good salary in a multinational company, but that skill, satisfaction which you get when you succeed in the matter, and when you realize it was because of your hard work you have succeeded in the matter, that satisfaction is out of the world, which you won't get in the world. One topic was on the art of cross-examination in this seminar. That really is important, even if you practice in civil code or criminal courts. Initially, I said you should be well versed with all the subjects. A lawyer is not a doctor. A lawyer is not a handwriting. Mr. Chomal is well aware. He is practicing in the trial court most of the time. Lawyer is not a handwriting expert. But you see how he cross-examines the handwriting expert. The handwriting expert will think, the time will come that he will say that I am not an handwriting expert. A medical officer who conducts post-mortem. The lawyer has never conducted post-mortem. But the lawyer has studied medical jurisprudence. Lawyer and understood the finer intricacies as to what is post-mortem, what is rigor mortis, how the death, what is the cause of death, how the death could have occurred, whether that weapon which is recovered is sufficient to cause the death, whether there was a firing, what is ballistic opinion, cross-examination of ballistic. You are not a ballistic expert, but you cross-examine the ballistic. Handwriting also, if you study, there are books on handwriting as to how to understand, identify the handwriting, that this is the handwriting of A, this is the handwriting of B, or this is the handwriting of C. There are various finer intricacies as to how to understand the handwriting. So you understand that also. So political science, psychology, sociology, criminal jurisprudence, medical jurisprudence, psychiatry, anything under the sun. This is the best thing about being a lawyer. And the lawyers must go to the trial court first. The fundamentals will be clear when you actually go to the trial court. They have to understand as to what is happening in the first court. The person is arrested, he is produced before the court of law. Which court is produced? As to how much time he can be remanded to police custody, what is police custody, what is judicial custody, what is his right under section 167 of CRPC, right to bail, powers of bail to the magistrate, what is 436, 437, what is 439, whether the magistrate has got power to grant bail in murder case, what is bailable, what is non-bailable, what is cognizable, non-cognizable, which offence is triable by the magistrate session court, what is the procedure for the trial before the magistrate, trial before the session court, what are the powers of the magistrate, what are the powers of the police to arrest. All this aspect you should understand in clear-cut terms and read the law. Keep yourself updated. You should know how to. There's one topic about citing judgments also, no? Which judgment you are supposed to cite. How to distinguish the judgment which is cited by your opponent. Your opponent may carry 50 judgments, but it's your skill which will enable you to distinguish those judgments from the matter which is before you. So facts of the case also can distinguish the judgment. You can argue that these judgments are not applicable in the facts of this case, but the judgment which you are relying are applicable in the facts of the case. Sometimes the same, it so happens in a different matter, you argue the point which is argued by your opponent, and there involves a skill as to now how you are supposed to argue this point. This is the skill. This is the challenge before the lawyer. And this, if you apply yourself and be focused, I don't think there should be any difficulty for you to become a successful lawyer. Another thing which I want to guide these newcomers is join some chamber. Earning is not everything. Nowadays, if everybody wanted within 2-3 months or 6 months, they want luxurious cars, and that should not happen. And that should not be the object. Be there for some time, try to understand the basic concepts. Join the senior chamber. That Gurukul should survive. Not that right from the day one you will go and start arguing on your own. See how your seniors argue, see how you draft the matter, read the matters which are drafted, observe them, sit in the court of law. By sitting in the court of law also we can learn so many things. You have one matter before you which is with you, but there are different lawyers who come and argue matters before the court of law. You can learn so many things while sitting in the court instead of sitting in the canteen. So sit in the court. These things everyone should keep in mind. And a criminal lawyer, as I have said, should know those elementary things. What are the elements of crime? You only read about 302, 326, 324, 320. But why a person commits crime? What are the causes of crime? There is something called as criminology. The student must have learned this subject. Study of criminals. If you study that, that is also going to help you. Theories of punishment. There are different theories of punishment: retributive, preventive, deterrent, reformative. There are schools of criminology: neoclassical, classical, positive, demonological. This you must have studied if there was a subject of criminology. It's not that only IPC, CRPC, read this also. What is ultimately crime? Crime is an act which is punishable by the penal law. The word crime comes from the word crimos. And punishment is provided to the person who commits the crime because that is actually the protection for the protection of the society. Why a person is punished? It's for the protection of the society. He should not commit the crime again. Others also should not commit the crime because they should know that he has committed crime. The deterrent theory, what is deterrent? The word deterrent means the object itself, it should deter others from committing crime. Reformative theory means it's for the object is to reform a person. We are providing legal assistance to all those poor people who can't afford. There are many persons who are languishing in jail who has committed a crime for the first time in life. We are required to help them. That is what does Se Humdard Tak is doing. You should have that informative approach. One opportunity should be given to that person to come out and reform himself in life. There are many persons who commit a crime because of the circumstances. This you will study in this law of subject of criminology. Causes of crime: poverty, financial instability, company, illiteracy. There are various other factors which prompts a person to commit crime. So does it mean that they are required to be in custody all throughout their life? Unless the crime is so heinous. So we are required to protect the society also. Otherwise, there are many people, as advocates Prakash Salsingikar has said, that many of them were in custody, they were not even aware as to they are supposed to be out on bail. Now I am told that some district magistrates, etc., they keep on visiting the jails periodically, and they apprise, I think, those under trial prisoners and even convict about their rights. So all these things, the volunteers of this organization done, and all. The cardinal principle of criminal jurisprudence is, as it is somebody has said, that prosecution has to prove its case beyond all reasonable doubt. In this process, even 100 persons are acquitted, doesn't matter, but once innocent person should not be convicted. That is the reason the burden is cast upon the prosecution to prove its case. So what is burden of proof? Then go to 102 of the Evidence Act. When does the burden of proof shifts? Read section 105 of the Evidence Act. What is evidence? Documentary evidence and oral evidence. Primary evidence, secondary evidence. What is primary evidence? What is secondary evidence? What is examination in chief? What is cross-examination? How to cross-examine? Cross-examination, of course, knowledge of law plus art. The trial lawyers are the real persons actually who work hard on a particular matter before the trial court. It is how the trial lawyer has conducted a cross depends the fate of the client, the person who is in custody. So how to conduct cross-examination? That topic is already discussed. I don't want to elaborate on it, but keep in mind how to conduct cross-examination. The first and foremost thing is the lawyer should know where to stop and what not to ask. Because one damage, then the lawyer tries to cure that damage. And second question, it further damages, then the third question. And then the sequence is, in the result, the case is fully damaged against the defense side. So it's a criminal lawyer's skill. That's the reason I have said you should know all these aspects of law. Not only a law, even general books. Like handwriting expert, ballistic expert, your cross-examiner. These are the practical aspects which everybody must keep in mind. And all the volunteers who are involved in this organization should know the rights of the accused. What are the rights of the accused? And should be provided to them. What rights should be provided to them? Every lawyer must read constitutional law. Merely because you say that I am practicing in the court of magistrate at Mazgaon, it's not necessary to read constitution. That's not should not be the idea in your mind. Every lawyer must know the provisions of constitutional law. The constitutional law is the parent law from which all the laws flows. There can't be law in force which is against the constitution. They are called as ultra vires the constitution. So constitutional law is the parent law. And rights of the accused, you learn then Article 19, Article 14, 19, 21, 20, 22. Some of the rights are also there in Article 20. Like no person can be compelled to be witness against him. No person can be compelled to give evidence against him. No person can be convicted for the same offence twice. No person can be convicted for the offence which was not in existence when the offence was committed. No person can be imposed a punishment which is greater than what is provided by the law at the time when the offence was committed. Then Article 22, right to be informed about the grounds, production before the court of law within 24 hours. And Article 21, the most important fundamental right of personal liberty. And you must have come across various judgments. The lawyers must have come across various judgments which are being delivered on day-to-day basis about the rights of the accused. You see those old judgments in the case of Sheila Barse versus State of Maharashtra, Sunil Batra's case, Hussain Ara Khatun's case. All those cases are basically based on Article 21 of the Constitution. Then section 40 about giving notice to the persons who is involved in offence of 7 years up to 7 years, informing him about the grounds of arrest, providing legal assistance to him, right to be informed, information being given to his nearest friend or his relative that he has been arrested in particular case so that he can engage, right to defend himself, right to have the lawyer of his choice. Even section 303 of CRPC and 304 you will find this provision. And production of the accused within 24 hours, excluding the time of journey, etc. etc. Then you should know the provisions of law, bail. Now the new law defines the concept of bail also. Otherwise, in the earlier 1973 Act, there was no definition of bail. What is bailable, what is non-bailable, you will find that in that schedule. So these provisions of bail, and there are various judgments as to being providing right, like DK versus case, Supreme Court judgment. Then that Arnesh Kumar's case is a very famous case, you must have come across. Antil's case. And there are various other judgments on the law, Gurbaksh Singh, M. Chandra's case, there are various other cases. And now there are various judgments coming. The long incarceration in custody violates Article 21 of Constitution of India. So many those persons who are languishing in jail, this organization helping them. So lawyers, the junior lawyers or the volunteers who are representing or going to represent them, impart justice to them, should keep all these aspects in mind. So Article 39A, as I have said, this Dard Se Humdard Tak, even the lawyer when he begins, he is in Dard. Till he establishes himself and provides Humdard to himself. So I congratulate this organization for holding such seminars and providing legal aid to needy, poor, marginalized people and who are illiterate people who really need justice. This is a commendable job. Congratulations to you. I think the lecture has gone little long. So anyway, it should not be, before the people say that you should stop, I should stop. And as I said, keep in mind one thing, reading, don't discontinue it. It is said that as soon as the person stops reading, he becomes old. If you continue reading, he never becomes old. Thank you, Advocate Prakash D and all others concerned with Prathamesh Gaikwad, you too. And I really remember that he had appeared before me, and I remembered his name today also, before he said that So all the best to all the newcomers, and I also wish all the best to the volunteers. Should continue this work of imparting justice. Thank you for inviting me on this occasion. Thanks a lot.